Hi, I'm Jason Tetlow, the founder of the law firm Tetlow Law PC. Welcome to the Steel City and Conemaugh Valley Law Advocate podcast. I've been helping clients with personal injury and medical malpractice claims since 2001. I created this podcast to provide an overview of the personal injury and medical malpractice processes and answer the questions I most often get when I first meet with prospective clients. My goal is to fight for my clients so they are fairly compensated when they are the victims of negligent actions or malpractice. If you need representation or just have questions, don't hesitate to contact me at 412 248 9600 or visit our firm website at www.tetlowlaw.com. That's TETLOWLAW.com. Any information provided in this podcast should not be taken or relied upon as legal advice. You should always consult with an attorney about the particular facts and issues of your case.
Welcome to the Steel City and Conemaugh Valley Law Advocate, a podcast dedicated to bringing you legal insights on personal injury and medical malpractice law. Brought to you by Tetlow Law PC and featuring the expertise of Jason Tetlow. Let's get this episode started.
All right, welcome everyone to episode 2 of the Steel City and Conemaugh Valley Law Advocate, your trusted legal voice for plaintiffs' personal injury and medical malpractice law in Western Pennsylvania. We're back with Jason Tetlow in episode 2, and we're going to be explaining what a personal injury case is all about. So in this episode, we're really going to explain what is a personal injury case, how does that differ from a medical malpractice case, and certainly I know that Jason and I discussed this, that whenever he meets with a prospective client, he takes as much time as necessary to really walk through what their case is all about, the specifics, the facts, the backgrounds, all those types of things. So I don't want to leave our listeners thinking that us kind of going through and answering specific questions is the way he would typically handle this, but we thought this episode would be valuable in terms of answering some questions that he commonly gets. So Jason, welcome back.
Good to be back, Pete.
So Jason, I know generally, would you agree that your practice is largely broken up into handling medical malpractice cases and personal injury cases? Is that fair to say?
Yes, correct. Yeah, I mean, probably more the majority is medical malpractice, but we do handle a good amount of personal injury cases here at the firm. A lot of that being motor vehicle accident type cases.
So when we're talking about personal injury, can you explain just generally what that means to you and how that is different from a medical malpractice case?
Well, so personal injury cases take on many forms, Pete. You hear a lot about like a slip and fall type case or, a motor vehicle accident type case or even a trucking accident type case. All of that falls under the umbrella of a personal injury type case. The legal elements of all of those cases is the same. And what we have to establish on our end as the lawyers handling those kinds of cases is certain elements in the law. And I don't want to like bore you or the listeners about what all of those elements are, but just in very general, we have to establish that there was a duty and that somebody breached that duty that caused harm. So like those are 4 elements there. There's a duty, a breach of the duty causing harm. And if I can give you an example, like in an auto accident type case, which falls under the personal injury umbrella, if you're stopped at a red light and another vehicle rear ends your vehicle from behind, that's somebody that has a duty of reasonable care not to rear end you, right?
Right.
Let's say they're on their phone and they're texting and they're not paying attention to what they're doing. So they have a duty to act as the reasonable person under those circumstances. Well, clearly they didn't do that because they rear ended your vehicle.
Right.
So that's the breach. So they breached that duty. They failed in that duty. And then the third and fourth elements of that are the causation and the harm. So did that breach of that duty cause you harm? And those are kind of the 4 basic elements of it. And you hear the term negligence too. Did somebody act in a negligent manner? And that falls in line with the duty and the breach. That's acting in a negligent manner. So, with personal injury cases, there's a lot of situations that fall under that name. And a slip and fall type case, somebody has a sidewalk that's really icy, and after a snowstorm, and it was icy for an extended period of time. Sometimes with weather in Western Pennsylvania, sometimes it's hard to completely eliminate all icy areas right after a storm or freezing rain or what have you. But, if that condition was there for a period of time, well, the homeowner or the property owner has a duty to clear out the ice and throw salt down and make sure that if somebody is walking along the sidewalk or walking across a parking lot, that there aren't those dangerous conditions that exist. So it's kind of just a general overview of what is a personal injury type case.
And that's different than a medical malpractice case where somebody specifically sought medical help from a hospital doctor, something along those lines, and something happened in one of those medical procedures.
It is the same in many elements, but it is different. The different part of medical malpractice cases in Pennsylvania is there's actually a whole separate set of laws, let's say, and it's called MCARE. And there's certain aspects that are required that I know we'll get into in another episode in a medical malpractice case that really involves experts, getting experts, retained. And that's really a big difference. So medical malpractice is really a different animal than the personal injury type cases. There's a lot more that goes into in general, not in every
Yeah.
situation, but in general, there's a lot more that goes into a medical malpractice type case.
So it's fair to say, I think, that if somebody's in an auto accident, if they have a slip and fall type of case, they get bit by a dog, those types of cases in general would fall under the banner of personal injury.
They would, correct. The most typical kind of personal injury case that, at least at my firm, that we handle are motor vehicle accident type cases. We do have some cases where people are involved in various, we call them premise liability, but that's sort of the fancy name for a slip and fall type case. Whether it's on ice or whether it's on, water in a store, or a defective condition of a sidewalk or a parking lot, that all falls within the personal injury realm. But here at our firm, we handle mostly the personal injury type cases that we handle are, motor vehicle accidents. And, we've handled some trucking accident cases here.
So, and I think you just described those four elements: the duty, a breach of the duty, causation, and damages are typically how you determine whether someone has a recoverable claim or not. Can we turn our attention for a minute to damages? Can you describe, because I think sometimes people might have all those other three pieces, but not the fourth, or enough of the fourth that says, hey, this is worth you hiring a lawyer or me to do this. So can you talk about personal injury damages a little bit?
I always like to use the word harm. Has somebody been harmed, from an accident? I've certainly seen circumstances, you might understand this, where somebody is involved in a very serious accident and the car flips over and the car looks like it's, the car's totaled and it's a mess. But people walk away with either no injuries, no harm at all, or very minor injuries. And, we're in 2025, so cars are built a lot better. They're a lot safer. There's all kinds of federal regulations that car manufacturers have to adhere to, and which is a good thing, right? Because, today's day and age, cars are just generally safer. So, maybe you don't see as many of the serious injuries from car accidents. It does happen, but that's happens in cases where there's an accident, there's a negligent act, somebody's texting and they're not paying attention and they cause a collision, and the person on the other end can walk away completely unharmed. And in those circumstances, if somebody comes to me and I'm hearing the story and they're talking about what happened, and if they have no harm and they have no medical treatment whatsoever, from a legal standpoint, it's very challenging to get that person a recovery for what they've been through. It's that fourth element that we discussed is the damages and the harm that they have to have in order to make some sort of recovery.
When I think you alluded to this, I hired you years ago for an accident that my family had, and it was a bad accident, and fortunately, we all walked away from it largely unhurt. And that was the right counsel that you gave me. Just to give the listeners a flavor of an example, in a small SUV with my entire family. So I have three kids in the car, one of them an infant in a car seat, my wife in the car. We're driving through an intersection, have the right of way. Somebody blows through a stop sign, T-bones us, flips the car several times. The car's completely totaled, and miraculously, we're all right. And I remember talking to you about this, and it's clear they had a duty to stop at this stop sign, and they didn't, so they breached that duty. Because they ran through the stop sign, they hit us and flipped us, and they totaled the car, but we were largely okay. And that really played into the whole scenario of like, yeah, you have all these things, a horrific accident. Thank God we were all right. But there's really not a whole lot of damages here to recover, other than the property damage and some minimal stuff in terms of what came through. And that's a prime example, I think, of what you were just describing, how damages is a critical element of the case.
Yeah, absolutely. And I can remember having that conversation with you, and
Right.
the case is over, and so I'm not worried about attorney client
Right. You're
confidentiality.
right.
I
I'm
mean,
giving you permission.
right? Yeah, right. I mean, first and foremost, you were fortunate. Really, your whole family walked away with limited injuries. I mean, I know there were some injuries and there was some treatment that your family members had, but I mean, that is an example of, hey, here's a horrific accident and horrific collision, but there wasn't a lot of harm, thank God.
Right.
Um,
Right.
and I think the opposite of that Pete, I'm sorry, is true in certain circumstances where I've been involved in many cases, many, many cases over the years where the opposite is true, where you look at the damage to the vehicle and there's not much damage, but my client ends up having a herniated disc in his or her neck and has surgery for it. And, if you look at the pictures of the vehicle, you might think to yourself, well, this really wasn't that bad of a collision. But, what you don't get from the photo is, really what happens to the client's body when the collision happens. Gets back to my point of cars are made a lot better today and they're able to absorb those impacts. So the vehicle damage is not necessarily there, it's limited, but the impact on the person's body is great, and causes somebody harm.
I think sometimes they even call them eggshell plaintiffs, right? That you take maybe somebody has a pre-existing condition or something like that, and it's aggravated by an accident that even though, like you said, it might be a minor collision, that if it causes
Right.
those damages, the two don't have to connect one to one with each
Yeah.
other in terms of
And
severity.
that's pretty good, Pete, that you're going back to torts, the
Yeah,
eggshell
right,
plaintiff,
right.
back to the law school days. But you're right. I mean, it's there is that saying which you take the plaintiff as you find him or her. And that simply means if you have, just as an example, if you have a bad low back and maybe you have like a bulging disc in your back and you're involved in some sort of a personal injury type incident, and because you have that pre-existing bulging disc in your back, maybe now the disc comes out a little bit more and now it's a true herniation, and it's causing an impingement on your nerve. And now you've got significant leg pain. That all from a legal standpoint, because a person may have that pre-existing condition, the wrongdoer and the insurance company for the wrongdoer, while they may try to use that to their advantage, at the plaintiff's end, that element of the law of the eggshell plaintiff is favorable to a client who has that pre-existing condition.
You take them as you get them. You don't get a credit for the fact they had some injuries that you certainly can't say, hey, I should be paid for the bad back I came to the accident with, but anything that happened from that point forward is fair game.
Correct. Did the collision, did the accident, did the incident, whatever it is, cause that condition to be made worse? And if that condition then became worse, however minor or however significant, then the person causing the collision, causing the incident, then would be, their insurance company, 99 times out of 100, then the insurance company would be on the hook for those damages, that harm that was made worse by the accident.
And so you just gave us a walkthrough of, how you determine whether someone has a case and an explanation of, damages and how that ties into. Now, I think you mentioned this in the first episode, but I wanted to just make sure this was very clear. So when someone comes to you to hire you as an attorney, you mentioned before that you do that through contingency fee basis. Can you explain what that means and how's a contingency fee work? And are there expenses outside of contingency fees that come into play in these types of cases? And maybe just briefly talk about what some of those typically are and how this all sort of is laid out at the end whenever you're resolving a case.
Yeah. So a contingency fee, it does exactly what it says. It's the attorney's fee is contingent upon success of the case. So generally speaking, when you get involved in a personal injury type case, the attorney's fees are going to be, let's just say on average 33%, a third. So, if you have a case that hypothetically speaking is worth, I'll keep the math easy for me. That's why I had to go to law school, because my math skills deteriorated. If you have a case that settles for 30,000, right? So a third of that is 10,000. So that's what the attorney's fees would be. So I've said this to many people over the years. There's not many professions out there where lawyers get paid upon success. But that's what happens with lawyers like myself that handle plaintiffs' cases, is we're only getting paid when there's success, meaning when the case settles or when the case goes to a jury trial or a bench trial and there's an award provided by the judge or a jury. Otherwise, we don't, as lawyers working on a contingency fee, we don't get paid because we don't bill by the hour. At least with my firm, I think I have one hourly case now, and that's a sort of a different scenario. And even then, it's not something that I'm not spending, just because of the circumstances of it. I'm not spending a lot of time on it, but you don't get a bill monthly from my firm. Whenever somebody hires us, I'm not charging by the hour. I mean, it's strictly based on a contingency fee. And then to your point about expenses, we pay the case expenses along the way. So what does that mean? Well, when we get medical records for a client, we have to pay the hospital or doctor's office to get those records. The biggest expense really in a personal injury type case is whenever we have to get an expert involved. So let's say it's a case that requires, an engineering type expert or an accident reconstructionist to go out to look at a scene, to do an analysis and provide us with a report. I mean, as you might imagine, those experts don't work for free. So that's an expense. We pay those experts. If we need down the road in a case to get the treating physicians involved and have the treating physicians write reports, that's an expense in the case. Or if the treating physician or another retained physician type expert provides deposition testimony or trial testimony in the case, then that's an expense. So those expenses at the end of the case are all tallied up, and then those are also recoverable in our firm. And that's the way it is with a typical personal injury type firm.
So you have your fee that's contingent upon success. You're covering the expenses, and the expenses are recoverable contingent upon resolving the case. So that if the case doesn't settle, or the case doesn't get resolved, or it's not found for the client, they're not out any money. You've borne the risk of all your time, your office's time, the expenses related to the case, on the chance that you're going to be successful for them and take a piece of the fee.
Correct. Right. So, I mean, if we go the distance and we go to a jury trial and we lose, we've lost those expenses too.
Right.
We don't, We don't turn to the client and say, hey, we've spent 10,000, 20,000. You now have to pay us that money. It doesn't work that way. What I like to tell people when I meet with them early on is that's why we have to do a good job on our end to get involved in cases, that we feel confident in, that we can establish all of those elements that we discussed in a case. Can we prove that there was a breach of some duty? And in your situation, Pete, if somebody walks away and they have no injuries whatsoever, well, unfortunately, just from a legal standpoint, there's not much of a recovery or no recovery that we can get the person.
Right. And in that scenario, using it as an example, no amount of experts and spending money on experts are going to create damages that don't exist. So you don't spend money that's not going to get you somewhere.
Yeah, and that's a good point. And I tell clients this all the time. When you're involved in an accident and you're having problems and you're feeling pain and you're having whatever it is that you're experiencing, I tell clients this all the time. Go get the treatment that you need. Okay? I don't do doctor shopping. I don't send clients to whatever other firms do, they do. That's not something that I do, but I tell my clients, if you need treatment, go get it.
Right.
Because one, you need it. It's good for you. You need to get that treatment. And number two, it will help your claim because that way it's documented. We have the documented treatment.
Yep.
But more importantly, if my client is having a certain issue, whatever it is, then you want to get that addressed from a medical standpoint.
Right. And do you ever, I'm sure you get this question often, and I'm sure the answer is it all depends. But generally speaking, if you're going to say someone, look, in a typical auto accident case, and obviously the more complex, the more damages, et cetera, it's going to change this equation. But can you give some benchmarks about what you tell people expectations about how much time they should anticipate it's going to take before you're even at a point to decide whether you can get the case resolved or not?
Well, Pete, that depends.
Knew that was coming.
It depends on many factors. I mean, a lot of it with automobile insurance cases in particular, just to use that as an example, Pennsylvania law only requires that a person drive a car Pennsylvania with minimum coverage of 15,000, right? So if I'm meeting with somebody and they have a serious injury, but there's not much insurance coverage there, that might be a situation where the claim can get resolved on the quicker side. Or I'm even telling clients, hey, you might be able to, or I might be able to do this for you, and get it resolved quicker, and we'll work on my fee. Because, if you have serious injuries and there's only 25,000 or 15,000 in coverage, then there's not much more that can be done.
Right.
Now, if you have a case where that, it's a serious accident, there's multiple parties, there's multiple insurance coverages out there, then yes, that's a situation where a claim could easily take 1.5 years, 2 years. The discovery process with depositions, and you're hiring the experts, and you're making sure that you have everything you need in order to properly present the case and establish all the elements of negligence and everything else that's involved, then yes, that could take a couple years.
Well, and I would imagine it's also important that you're leaving enough time that you fully understand and the client fully understands the long-term consequences, any injuries they've suffered, because once you settle a case, that's generally it, right?
Correct. Yeah. I mean, once a case is resolved and a release is signed, that's it. You get one bite at the apple. Once you take that bite, it's it. You can't go back. So I remember, one thing that I advise clients is if I get hired early on in the process, many times I tell clients, like, we just have to wait and see. There's no rush to do anything. Because if that person is still treating, they're going to physical therapy or they're going to the chiropractor and, their neck or back still hurts and they're seeing the surgeon and the surgeon is saying, well, just try physical therapy, see if that works, try injections, see if that works. We don't know the full extent of their harm. Sometimes it's a wait and see approach. I had a client, this is many years ago, she was injured, I'll just say, while on a bicycle. And by all measures, it seemed like a very minor injury. from what happened to her. She got clipped by a vehicle, was driving by, and the side view mirror of the vehicle clipped her leg. And early on, it seemed like it was a minor injury. But she was consistently treating. She was developing this really bad chronic pain from it. So I can recall vividly speaking with her father and just saying, let's just wait, let's just wait and see how she does. And I mean, in that case, took from beginning to end, I don't know the exact amount of years, but it was at least 4. And like that was the right thing to do. She ended up having a lot more of a serious injury than we thought initially. And had we resolved her case early on, then that would have been it. She would not have received full compensation for what she had been through.
Well, keeping in mind that you need to make sure that everybody fully understands the extent of the injuries before any final decisions made, would you ever advise a client, well, just, you've been in an accident. You don't need to contact me until you know what your injuries are 2 or 3 years later. Are there any other deadlines they need to be aware of? And why would they talk to you earlier in a case versus, just waiting to see if their injuries have resolved themselves?
The most important deadline is the 2-year statute of limitations in Pennsylvania. You have 2 years from the date of the incident to file a lawsuit. If the lawyer is doing their job, they're not going to try to enter into some sort of a quick settlement for you. Okay. Especially if you're still treating and the full extent of your harm is unknown early on. But to get a lawyer involved early is good because then you avoid the potential for insurance companies contacting the injured person, trying to get statements. And sometimes when a statement is given, something could be taken out of context or something could be said, I'm not going to say under duress, but something could be said that maybe is not entirely accurate. And now you're kind of beholden to that statement down the road. So getting a lawyer involved early in the process is always best. It always is.
And if we use that example you just described, where it took 4 years to fully understand the extent of your client's injuries, I would assume that you were able to take those 4 years because you filed the lawsuit within the time frame necessary to make sure that you weren't going to be losing the case on some technicality.
Well, correct. And I think in that instance, we did file the lawsuit. However, that brings up a good point, Pete, is there is an exception on that 2-year statute of limitations when it comes to a minor.
Okay.
So if you're under the age of 18 and you're involved in some sort of a personal injury type matter, you really have until your 20th birthday. So it's once you turn 18, you've got 2 years from that point to file an action. So that is the exception. But correct, under circumstances where I'm representing somebody who's 18 and older, we're going to make sure that we get that lawsuit filed within 2 years. Absolutely.
Which is the importance of having a lawyer on your side, because you can lose on technicalities without ever getting to the facts of your case if you aren't aware of all these deadlines and things like that.
Yeah, and what's tough too sometimes, if you want to hire a lawyer at the 11th hour and your statute is running in days or weeks, sometimes it's hard to find a lawyer to take on the case with that little time.
Right.
In my experience, Pete, and doing this for as many years as I've been doing it now, typically somebody that does have, the significant harm from an accident, from some sort of a personal injury type claim, a lawyer is typically hired earlier in the process, which is a good thing. However, there are circumstances where I've been contacted. I actually did get somebody, this was on a medical malpractice type case, but somebody had contacted me about a potential case with the statute running like later in this month. And I actually had a conflict because I knew the doctor involved so I had a conflict. I didn't want any part of it. But even if I didn't know the doctor involved, it's probably unlikely I'm going to get involved in a case with only a couple weeks to spare, because there's just too much that needs done before you get to the point where you're filing a lawsuit.
And that doesn't leave you as a lawyer who's investing potentially a lot of time and money and expenses into something to determine whether or not the case has a good chance of succeeding or not.
Right. Exactly. I mean, it's, we have to do our our due diligence, our investigation on our end to determine whether or not it's a viable case. And sometimes auto accidents are clear. You know who's at fault, but not every case is like that. There's a lot of cases where you really have to determine, are we able to establish that the other side was negligent? Okay. Even though the person maybe has serious injuries, well, we can't get to that element until we determine, was there negligence and can we prove that, whether it's through experts or other means.
And so you mentioned here a couple minutes ago about Pennsylvania has a minimum amount of insurance that's required in order for you to drive, and it's not a ton of money, $15,000, I think you mentioned. Are there other elements of insurance related to accidents or auto insurance that come into play when you're analyzing what someone might have in terms of options for recoverable damages?
Yeah, I mean that's a really good question. There's a lot more to automobile insurance policies than people think. And I'm not going to act on this, but I've always thought about having my own insurance brokerage with the knowledge that I have now of automobile insurance laws, because I meet with people many times over the years and I look at their what's called their deck page, which is usually the one or two sheets that outlines the specifics of the automobile insurance coverages. And sometimes people just don't have the proper coverage. And it's not through their own fault. It is not. Things just usually are not explained to them early in the process of the importance of other aspects of coverage. And a few examples of that are, probably the biggest one is limited tort and full tort.
And those are options you can choose on your insurance policy.
Right. Those are options you can choose. And many times you're sold on certain options on the fact that you can save a little money. But sometimes saving a little money ends up really causing problems for you down the road if you are unfortunately involved in an accident. Without getting into all the crazy details of it, but limited tort and full tort, limited tort does exactly what it says. It limits you for what you can recover if you're involved in a case, in an accident. So in any kind of accident, there's certain elements of damages that you can recover. And again, I'm speaking very broadly here, but there's, the non-economic damages and the economic damages. The non-economic is the pain and suffering and mental anguish and what you've gone through as a result of an accident. The economics are your wage loss and any out-of-pocket medical expenses. Those are generally your economic damages. And if you have limited tort, you're limited in that you can only recover those economic damages. You can recover the non-economic damages if you have a quote-unquote serious injury. So if you're involved in an accident and you've limited tort, and let's say you have some neck or back pain, and you see a chiropractor for a little bit, or you see a physical therapist for a little bit, and then you're fine, you're generally speaking, this isn't in every case, but generally speaking, you're not going to be able to recover those non-economic damage. If you're full tort, it doesn't matter. You can recover the non-economic and economic damages. So that's one area that I see. In fact, we actually just had this happen this week in my office. Our client, it was a husband-wife. The husband had more significant injuries. He had some fractures and what have you, and the wife has very minor injuries, but they have limited tort. So I was able to already make a recovery for the husband, but for the wife, we're probably not going to be able to make a recovery because they have limited tort. So therefore, with her minor injuries, she can't recover on the non-economic harm, that she's suffered because of the limited tort.
So you have, and this is making a claim, and we all have who drive, we have insurance related to the vehicles we're in that covers us and others. Whether we hit somebody, we're hit, it comes into play. But what happens when you're in an accident with somebody, it's their fault, and they have no insurance?
That's where it's important to understand the insurance coverages that you have. And to your point, Pete, whenever you enter into an insurance policy, you have your liability coverage, meaning if you cause an accident and somebody's harmed, depending upon what your liability coverage is, that's going to be the limit. Perhaps sometimes more importantly, under certain circumstances, there's what's called uninsured and underinsured coverages within your own policy. And to your question and to your point, if you're involved in an accident where, let's use a basic example, you're sitting at a red light and somebody rear ends your vehicle, and that person who rear ends your vehicle has no insurance. They let their insurance lapse for whatever reason. So they're uninsured. So then you can then present a claim with your own insurance company, assuming that you have the uninsured coverage.
Right.
It's the same example if you're sitting at a red light and you get rear ended and God forbid you suffer serious injuries. If the person who rear ended you only has minimal, small coverage, therefore, under the law, we say that person is underinsured. They didn't have enough coverage. So that's when you turn to your own insurance company and you bring that claim for underinsured benefits. It's a contractual claim with your own insurance company. So many times, and again, I've had this happen many times over the years where clients may just not have enough underinsured or uninsured coverage, but they have serious injuries. And it's difficult.
Well, and it sounds like the layers of insurance and what may come into play or not come into play is complicated. And if you don't know what you're doing, or you're dealing directly with the insurance company who's going to try to, get out of this for at least amount of money possible, you run the risk that you're not maximizing what you're entitled to.
Right, 100%. But that all starts at the beginning. The key is, I tell people this all the time. I don't fault them for the coverages they have because it's not explained to them from the beginning. And sometimes if it's explained to you that you can save a little money, then and I get it. You want to save a little bit of money, but the coverage is not going to be as good. And I would tell anyone, if you have limited tort, get rid of it and go to full tort. Because I've seen many circumstances where there's not much I can do for people if they have limited tort.
I would imagine there's a lot of people that they don't give a second thought to their insurance until something like this happens. And maybe you start off and you can't afford bigger coverages and life goes on, and you've just never re-examined it. I mean, that should be, ultimately you would think the responsibility of your insurance agent to bring some of these things to light to you to see, do you need to up your coverages in any areas? But if not, and you're not thinking about it, you're kind of on the autopilot. And given the options today, you would have said, yeah, I would have paid 25 more bucks a month or year or whatever it is to have this coverage if I knew what it meant. So maybe, I think what you're saying is there should be a whole episode just on insurance coverages in Pennsylvania.
Right. We could spend a good amount of time on it, but
I imagine.
Yeah, you brought up a good point. I mean, it's many times it's at the initial phase when you're dealing with an insurance agent, and people just are not fully understanding the coverages that they're paying for,
Right.
through no fault of their own. That happens, and I'm talking about all kinds of people. I've dealt with a lot of professionals over the years, and I get their policy, and and sometimes it's been friends of mine, that maybe that person has a good job and seemingly they're doing well, and I get their policy and I say, "Are you crazy? Well, your insurance stinks." But again, like life gets in the way, and you're doing your job, you're raising your kids, and you're not thinking about that. But it's important.
Yeah, and you could see the scenario where then somebody says, "Do you want to spend $1,000 a year on your insurance, or $2,000 a year?" Everybody's going to say, "I want to spend 1,000," but you have to understand what it is you're putting at risk by doing that. So it sounds like, again, there's a lot of full tort, limited tort, underinsured, uninsured. I know there's stacking. There's all these different things that could come into play on policies that make it more difficult than you would initially think in navigating through all this stuff, especially if it's a serious accident and you're looking to see where are there coverages that might compensate someone for the injuries and the problems they're going to have in the future. And again, as we mentioned in the first episode, and I think again here today, once you settle, you're done. You can't come back and say, you know what, I'm more injured than I thought I was. I would like to reopen this. You can't. So you have to really be cautious about making these decisions properly at the time that you do it. So I want to get into a couple other questions I think commonly arise in people coming to you largely related to car accidents. So is it a problem that, an accident happens, a police officer's involved, they're taking an accident report or whatever, and they at the scene tell the police officer, I'm not hurt, I don't need any medical care. They turn it down or whatever, but days or weeks later, something pops up that they realize, oh, I had something I wasn't recognizing then. Is that a problem? Is that something that you can work around with?
Yeah, it's definitely something you can work around with. And that gets back to my prior point of what I tell my clients is if you are having problems, pain, whatever it is, whatever medical issue you're having from an accident, you want to go get the treatment because in that circumstance, I've seen it before many times, Pete, where someone's involved in an accident and they do tell the police officer, or maybe the ambulance personnel come to the scene and they say, oh, I don't need to go to the hospital. I'm fine. But they wake up the next day or 2 days later and, their neck is killing them and they're having pain that goes down an arm or what have you. Under those circumstances, then yes, you want to go get the treatment that you need. So, while it might be a point that's brought up by the defense, well, hey, listen, you told the police officer you were fine. And now all of a sudden you're saying, you've got this neck herniation and you had to have surgery. Well, yes, because it didn't really manifest itself until a day later or 2 days later, which is common. Because sometimes when you're involved in an accident right away, you could be in shock a little bit, and you're not thinking clearly, and maybe you're not feeling everything that you should at the time because of what you've just been through. So I've seen that many times. That's a really good question. And certainly the defense will try to use that to their advantage, which is understandable. But again, as long as you're getting the treatment that you need. Now, if an accident happens on, January 15th and you don't see a doctor until July 15th and 6 months goes by, that's a problem. Okay.
Right.
Okay. Because those injuries and the harm that you sustained is not going to take 6 months. Generally speaking, I'm not a doctor, but generally speaking, it's not going to take 6 months for those injuries to come to light. So there is certainly, and you can't draw a line in the sand and say, if that person didn't get treatment within a month, then they can't recover. No, it doesn't work that way. But the longer the period of time from the date of the collision, the more that the defense is going to use that to their advantage to say, you're not injured from this accident. It's from something else, whether it
Right.
be, you had a degenerative spine, and don't blame us. Your back just is bad to begin with.
Right. Yeah. You just don't want to leave room for it to be interpreted to say something else happened in between here that we're not at fault for.
Right. Which is why my advice is, again, if you're having issues and you're feeling the pain and you think you need treatment, by all means, go get it.
Right.
And again, that's more so just to try to help out my clients medically, that they go seek out the medical expertise that is needed to get them better.
Right. It's sort of, I guess, related to this, or maybe it's different. What happens when someone's injured on the job?
Right. So that's a whole different animal. Good question. There's all kinds of circumstances that come about, but let's just say, just if you're at if you're at your employer and you're on the clock and you're injured, that will fall under workers' compensation. And workers' compensation is really different than, the so-called personal injury type cases. There's a whole separate court system set up for workers' compensation claims. I used to handle them many years ago. I don't handle them anymore because there's too many nuances with workers' compensation law that I'm not familiar with. And I do get calls on workers' compensation cases. In fact, I just got one yesterday, as a matter of fact. And there's very good lawyers that I refer workers' compensation cases to. But it's a very specialized area that I don't get involved in anymore. Now, there's certain circumstances where if somebody is injured on the job, like I'll give you an example. I had a case several years ago, actually, where there was an explosion at a steel plant. And that resulted, as you might imagine, in multiple serious injuries. But there was a lot of parties involved because there were contractors that were at the job site doing certain things. And when that happens and you're an employee of that company where the incident happened, there's a what we call a third party who may be responsible. You actually, under those circumstances, would have two claims. You would have your compensation claim with your employer because you're injured on the job. And then if there's a third party who is also responsible for your harm, then you can bring a separate claim against that third party.
So there are some circumstances where if it's depending on what's happening around the work duties and what's happened at the site, that there might be a more traditional personal injury claim that could come into play.
Correct. I've seen that a lot, and I've handled a lot of cases. A lot of that deals with work site injuries, like construction sites in particular. I've had multiple construction site cases where there's multiple contractors and subcontractors on a certain site. Somebody's injured, but it was the subcontractor that came in and didn't properly cover up the hole in the ground, or didn't properly put the fencing up, and somebody leaned on a fence and fell. I'm just that's a situation where, that even though you're injured on the job, but if there's that third party, somebody who's not a co-employee with the same company that you work for, then you would have a third party claim. But then you get into all kinds of subrogation issues with the workers' compensation, but that could be a topic for another day. But
Well, expanding on that one more scenario, because I would imagine it happens somewhat commonly, is all right, someone's on the job, but they're driving, and then they're injured by somebody else who's at fault while they're driving the company vehicle or while they're working. Is that a similar to what you described, but there might be a personal injury element to it with workers' comp, or
yeah,
yeah.
yeah. I mean, let's say you're driving a work vehicle, whatever it is, a work van, and you're out on a delivery. And while you're out on a delivery, you get T-boned. Somebody runs a red light and T-bones you and causes injuries to you. That is the circumstance where you would actually have two claims. You would have your workers' compensation claim because you were injured while in the course and scope of your work, because you're out on a delivery. But you would also have a third party claim against the driver that T-boned the vehicle and caused harm to you. So that's an example of where you could have both a workers' compensation and a separate claim, personal injury type claim, against the other driver.
So like the insurance issues where there's a lot of layers to it, there's a lot of detail to it. This one sounds like it can be very nuanced, and probably the best thing is for someone to call you and you're going to walk them through whether they have a sole workers' comp claim and direct them to some options for them on that, or whether it's one of these hybrids that has an element of a personal injury claim you could help them with to help them guide through what their options are at that point.
Yeah, correct. And every circumstance is different, obviously, but sometimes when I've been involved in representing individuals at a construction site or a work site, and there are multiple subcontractors at the site, it can get very detailed. It can get very confusing sometimes to figure out who is responsible. So yeah, but those are all situations where if it's determined that there is some workers' compensation claim to it, certainly I can discuss it and figure out and get another lawyer involved who has that specialty. My specialty anymore just has, been focused more on the personal injury, medical malpractice type cases.
What if we have an auto accident that involves a fatality? How is the person who died represented? What are their options for the person who unfortunately passed away in an accident?
So that's whenever you're dealing with an estate, right? So individuals that unfortunately suffer, catastrophic injuries in an accident and have passed away, then I'm dealing with the loved ones. And was there, did that person have a will or did they not have a will? If you have a will, then you look at the will and you see who is named the executor of the estate. So then that executor would then really become the quarterback of the claim, so to speak. And that person would, if we have to file a lawsuit because of the incident, then we would get the estate opened for litigation purposes, naming that executor in the will. That person then essentially is acting at the best interest of the estate. Typically under most circumstances, it's a spouse, or if it's a child, an adult child of the deceased that is the executor of the estate. Now, if a person dies without a will, it gets a little trickier in that, you still have to open up that estate. And if there's a surviving spouse, it's generally that surviving spouse who would be sworn in as the administrator of the estate, then act as the quarterback of the claim. And that person would have a claim to theirself as a rightful beneficiary of the estate. So just because somebody has passed away from an accident, whatever it is, that claim then gets handled by the administrator of the estate, working with the attorney.
So obviously, just because they passed doesn't mean they don't have a claim that can be made. It just has to be made through a different process of representation.
Right, exactly. And then we have different elements of damages in Pennsylvania. For the naming of it gets a little weird, but it's called there's a wrongful death act, and then there's a survival act. Those are elements of the law that address the damages that are recoverable when somebody has died from a particular accident through somebody's negligence.
Gotcha. And then you mentioned earlier about, the statute of limitations being extended for somebody who's under the age of 18. Similarly to an estate, is there a different process for representing someone who's a minor?
There's still generally that 2-year statute of limitations involved whenever there's a death case. Generally speaking, it's 2 years from the date of death is the deadline. So I might get involved in a case where, somebody is harmed as a result of, medical negligence or a personal injury type case, an auto case, trucking case, and maybe that person lives for a period of time and then that person dies. And if the death is as a result of the negligence, then you would have 2 years from the date of death to file a lawsuit in court to preserve those claims.
Well, let's assume it's not a death, but there's just a minor involved in the accident. Can you represent a minor directly, or is there a different process for representing the minor in their damages?
Yeah, so the minor, it's going to go through the parent or legal guardian. It's who you're going to represent through, that your client is really going to be the parent or legal guardian acting for the minor.
Gotcha.
Right. So the minor, right. So somebody's 18 years old, they have to be there with their parent or legal guardian. And that legal guardian or parent is making the decisions for the minor, essentially. So, and the thing with minor cases, Pete, is I've had many of them over the years, and it's actually a very good process in place whenever a minor's claim does get resolved. So what we have to do is we go through a process with orphans court to get that settlement approved. The judge actually has to approve that settlement. And then those funds for the minor are always protected until that minor turns 18. So there's all different kinds of avenues for that. There's, we get involved with cases where there might be a structured settlement where the parents, once a case is settled for a minor, there's certain payouts over time, maybe at age 18, 20, 25. And you can do, there's various ways that you can structure the money. Or I've had cases settle with a minor and it doesn't make sense to do a structure. So, maybe the minor is 16 years old. And if you're dealing with not a ton of money, we'll just put that money into like a CD. We know that there's going to be interest earned. We're not going to go out and buy some startup stock, and the court won't allow that.
Right.
And all of a sudden, 2 years later, there's no money left because the stock market went way down or what have you. So that money for the minor is always protected, and it's protected through the courts.
Gotcha. So Jason, as we come to the end of episode 2, a couple last questions here to wrap this up. So let's assume somebody is injured in an accident, injured to the point where they're off of work for an extended period of time, they're the breadwinner for the family. Number one, how is that handled? What are the options? What should they be looking at, or you would be looking at to help them, guide them through that process? And then number two, let's assume they get a settlement. Is a settlement in a personal injury case taxable or not? Is that considered income that they're going to have to pay taxes on?
So to answer your first question, I mean, if you're earning money in a job and you're injured in an accident and you can't go back to work, those loss of earnings, loss of future earnings is all an element of the damages in a case. So it depends on the circumstances, obviously, but many times what we do in cases is we hire an expert economist who will review tax returns, pay stubs, W-2s, employment file, review everything, and then provide an opinion on what's the loss of future earnings. And that includes fringe benefits too. Like if you're getting health insurance, what's the value of the health insurance? Other benefits that you're getting. There's value placed on all of that. So that's how the loss of earnings, loss of future earnings, that's an element of damages in a case. As far as the taxability of a personal injury type settlement, believe it or not, and again, I always tell people, talk with your accountant about this, but believe it or not, personal injury type settlements are not taxable. They might be reportable, but they're not a taxable event. So if my clients have an accountant, I always make sure that they tell them, hey, these funds that I got are from a personal injury type case, because it's not taxable. Believe it or not.
That's a good thing that comes out of all that in the end.
Right.
Well, Jason, any other general points you would like to make before we wrap this up? I know our next episode, we're going to be talking about more specific details about handling personal injury cases and some of the mechanics that go into that. So we'll have a chance to keep on this topic a little bit more. But anything else you want to add before we move on to our next episode?
No, I think we covered all the pertinent topics, so I appreciate it.
Well, that's great. Well, appreciate your time. Welcome the listeners to join us for episode 3, which is handling personal injury cases. And we'll be back to, again, discuss in more detail how those work. So thank you and stay tuned.
Thank you for listening to this episode of the Steel City and Conemaugh Valley Law Advocate, brought to you by Tetlow Law PC. If you're in need of legal representation, visit tetlowlaw.com today to connect with our team. We look forward to helping you win your case, and we'll see you on the next episode.